Hi, my name is Patrick and I'm the co-founder of LanaPro. On today's LP Minute, I'm going to talk about how warranties of fitness for purpose can slip in through the back door. A warranty of fitness for purpose means the seller knows the buyer's particular uses and the seller's product or service will meet those uses. In commercial contracts, sellers try hard to avoid that warranty and instead warrant as to say meeting clearly defined specifications. But a buyer can add this to the specification itself, so it enters the contract through the back door. For example, let's say a peanut butter manufacturer buys lubricants for its machines. The seller warrants that its lubricants meet the specification, but that specification states that the buyer intends to make peanut butter, and this lubricant will perform equally well on all of buyer's machines for this purpose. It turns out the buyer's new machines run much faster than his older ones. As a result, the lubricant doesn't perform nearly as well on the new ones, and part of the manufacturing line stops. There's now a river of half-made peanut butter flowing through the manufacturing plant, and an army of chipmunks invade for free food. And everyone knows that chipmunks are notorious for their poor manners. The lubricant seller may now be on the hook for this mess. The seller should have excluded the intended use language from both the contract and the specification. This has been your LP Minute, which has hopefully been helpful but is not legal advice. Watch a few more, hit the like button, and download more software. Thanks.